I noticed a 45 days where the tox lab is required to complete their analysis. I don't see anywhere where there's a remedy of what is going to happen if they don't comply within 45 days. And am I correct in assuming that that is then the court's inherent authority to either dismiss the charges or hold the tox lab in contempt? And what really concerns me is where it says that the diagnostic evaluation treatment recommendation shall be prepared under the direction of the court. And as we all know, that our federal law is very clear that any unlawful user of or addicted to any controlled substance uses their Second Amendment rights. So if the court is directing this evaluation and recommendation, I don't see any provision here where the court informs the defendant that they will jeopardize the Second Amendment right if they are found to be an unlawful user or addicted to any controlled substance. Is there any notice of Second Amendment rights being removed or placed in jeopardy?
Senator, the amendment does not particularly contemplate that issue. There's no language explicitly directing the courts to inform any individual of effects of firearm rights. But I believe you are correct that under 18 USC section 992, that it's unlawful for any person who is addicted to, or who is an unlawful user or addicted to any controlled substance to possess firearms.
And so in addition to the fee, it actually says that their license may be revoked by Department of Health. Is that accurate? Am I reading that right?
That is correct.
And so do we have any information on what treatment agencies might be willing to service this population given these limitations?
Senator Dingra, we feel like you're litigating right now.
Oh, sorry. Well, I'm a litigator, but yeah. Thank you. I think I've made my point.
You mean you think you've had your questions answered?
Waiting for answers.
This bill, we're trying to fish around for a solution, but we don't. There's no data to support the decisions that we're making. And when we jump to an immediately higher criminal level, we don't know what the impacts of that is going to be, as opposed gross misdemeanor versus simple misdemeanor, or even considering a felony down the road, whatever. So I think it's important that JLARC do a study on this issue because JLARC has implemented a new racial equity tool that they're going to be looking at our state programs to see, are there disparate impacts and what are those impacts? And I believe that a lot of these impacts are the result of this so-called war on drugs that has had disparate impacts over the years and which we're trying to make adjustments for right now. So with the JLARC study, I think it's really critical that we gather that data so that we can look at this problem again down the road, which is...
I'll just say I've actually really appreciated Senator Braun even coming to the SURSAC committee meetings for the last year and a half, and there were some of the more challenging committee meetings that I have attended because of the nature of the discussion and the passions that people in that committee had. And I truly do want to thank every participant in the SURSAC committee for the work that they put in. I would have been very excited to support Senator Robinson's bill that was referred to this committee because it can actually work. You can have it running and there will be no issues with it. I always like to be practical, and unfortunately, the bill that we have before us, it just sets us up for future problems. And I'm just going to go over 3 of the reasons why I have such concerns about voting for this bill. One of them starts off with the 45 days for our tox lab. This is setting up the true blood situation we have with the competency forensic evaluations. We are setting ourselves up to either be held in contempt or have dismissal of cases, because those are the two options available to the courts when they fail to meet the 45-day. And I just don't think that we need to set ourselves up for that kind of catastrophe. The second issue that I think is extremely concerning is the mandating of minimum days at the point of a condition of sentence. So this is not a mandatory minimum sentence like we do in standard statutory construction. This is, I have great concerns about the separation of power issues, but I'll let the courts chime in on that. The biggest issue with that mandatory 21 days or whatever that time may be is actually a problem that Senator Gildon had identified with what's going on with graduated reentry and DOC. And I've really appreciated that he reads the overdose fatality reports, because what we have found, and of course we have data on this, is that when individuals are released from custody without treatment, the chances of them ODing is very high. And what we are setting ourselves up is actually to see more overdose deaths, because people have to be mandated into custody and then released without treatment. And we have data on that. We know that's going to happen if we do the 21 days mandatory time on there. The third thing, is actually a loophole in our gun laws that this bill is closing. Given that the evaluation and treatment is going to be prepared under the direction of the court now actually has the ability to make sure that we are addressing federal gun rights through the system. Unfortunately, this doesn't have the notice provision, but I'm happy to work on an amendment for the floor. And so we will have to make sure that the court is notifying individuals at the time that they're ordering the substance use disorder evaluation that if they're found to be an unlawful user or addicted to any controlled substance, that they will be losing their federal Second Amendment rights. And then we do have to make sure that we have processes in place that notify them of the ineligibility to possess a firearm and do the surrender forms. But we have cross-references to that. So that is a part that's missing, but I am actually glad to see that we are closing this very large loophole in our gun laws. But even with that amendment, that part that I do like, I will be a no. Thank you.
Thank you. Senator Wilson.